Hello and welcome to our show. On this episode, we're going to talk about how to get approved for disability benefits. And to do this, we're going to share the top 7 reasons claims get denied and what you can do about it.
You're watching Your Disability Lawyers with David Share and Samantha Share. Contact Share Lawyers today for a free consultation. There are no fees unless you win your case.
So the reason we were calling this How to Get Approved is that by understanding the reason claims get denied, you can plan your application and hopefully avoid some of those pitfalls or address them head on in making your application, which will give you a better chance of getting approved. Bearing in mind that the insurance companies are looking for ways to say no, not to say yes, but if you give them the right evidence at the get-go, there's a better chance you can get approved. First on our list is you're denied because you have not provided sufficient medical information, or they say it's insufficient medical information that's been provided. What does that mean? Well, if your doctor fills out the attending physician statement and all it says is disabled in sort of a general way, that's not going to be good enough for the insurance company. They're going to say we don't know what the reason is that you're making this claim. So if the doctor can provide a little more elaborate description, and you too in your application, or provide test results if you have them, an x-ray or something that's showing that there's an objective problem in your lower back that's causing the back pain. So more information in that initial application that it helps to prove your case would be a good idea.
So the second reason that claims get denied is that the letter says you do not meet the definition of disability. I'm talking about the denial letter from the insurance company. So under most insurance policies, there's a definition of disability that essentially says that a disability is a medical condition that is preventing you from working in your own occupation or in any occupation. So some people say to me, well, I show that I have these medical condition. Isn't that enough? Why are they saying I don't meet the definition? I don't understand. But the reality is that when insurance company says you don't meet the definition of disability, it's not that they're saying that they don't believe you have a medical condition or that you're lying about your medical condition. What they're saying is, yes, we recognize you have XYZ medical condition, but we do not believe that it's preventing you from working. So how to avoid getting denied on that basis, I would say similar to what David said, you want to provide as much information as you can in the forms about how those medical conditions are preventing you from being able to do your job. And talk to your doctor about that too. So, if you have a chronic pain condition, you have back pain, you say, well, I can't sit for long periods of time. I can't walk. I can't carry heavy objects. Those are all things that I'm required to do in the course of my employment. If it's a mental health claim and you have difficulty with concentrating, focusing, or you have anxiety or panic attacks, don't just say that. Say, I can't focus. I stare at the screen and I can't, form a coherent argument or do my work. I can't talk to people. I have anxiety about talking to people and I'm in a customer service job. Give them a little bit more flavor as to why does that medical condition prevent you from being able to do your job.
I agree with all of that, and that point is a good segue into the next reason that the insurance company believes you can work. They say in their denial letter, we understand you have all these problems and so on and so forth, but despite all of that, we believe that doesn't prevent you from doing your work. And Samantha talked a fair bit about that under the previous point. But I think under this point, to understand it a little better, is an example of, say, someone who was diagnosed with fibromyalgia 15 years ago and managed to keep working with fibromyalgia for many years, and now they're putting in a claim still based on fibromyalgia. And the insurance company is going to say, well, look, you've worked with that for 15 years. Why can't you work now? And I think that it's important to explain what happened, what occurred. Was there something else in your medical profile, like degenerative changes in your spine, or something else in the aging process that said, I could do this for many years, I soldiered on, but now I've got to the point where the pain is just beyond the scope, and flesh that out so that they understand the before and after kind of a picture. That's harder for them to say no to than if you say fibromyalgia, and the history shows I've been suffering with that for the last 15 years without any frame of reference as to why now is different. So I would underscore that you really should focus on explaining the difference.
Another reason that insurance companies deny claims is that their doctors believe that you can work. So their doctors, I mean, most people have no knowledge that an insurance company even has a doctor, because that doctor never calls the claimant, never examines them. But most insurance companies have what they call a medical consultant. As typically, most of them are family doctors by training. They're not specialized. And they essentially do a paper review of the claim. So they read it and they say, well, based on what's on this paper, we think this person can work, without ever actually speaking to the claimant or knowing anything about them. And they're doing that because the insurance company wants to have something they can rely on to say, look, our doctor says you can work, so we can deny your claim. Ha ha. It's kind of hard to avoid that, because I think insurance companies do that in most claims. They get a doctor to review it so they can kind of check off that box and say, look, we had a medical consultant review it. But by providing the additional information that we've been talking about in some of the other categories, I think that would sort of lead to more questions, and perhaps the medical consultant will scrutinize it in a little more detail and say, okay, well, this person wrote down that, they're having difficulty concentrating, and what is their job involved, why is that relevant, and perhaps, with more information, we can only hope that the medical consultant might actually look at it in more detail. I don't think we can really control what's happening on their end, and unfortunately, the vast majority of those, cases will eventually get denied, or certainly the ones that we see. But we can try to prevent that from happening.
So next on our list of most common reasons for claims being denied is a letter saying that you have a pre-existing medical condition. Another episode of our show, we talked about this at some length, so I'm not going to go into great detail, but this only applies to a subset of people that have had coverage for a relatively short period of time, usually less than 1 year. And if you've had coverage under your group plan for less than 1 year, and have had a medical condition in the past that you are getting treatment for ongoing, or medication, it allows the insurance company to take a look at your prior medical history to see if they can exclude your claim based on you having a pre-existing condition. In order to address this in your initial application, you should be aware of whether or not a pre-ex could apply to your case, and be mindful of that when you're getting the forms completed. You may not be able to get around it, because it may in fact be a pre-existing medical condition, but if it seems like something completely new from what you were experiencing in the past, and you speak to your doctor about this concern, they may be able to assist you in framing your application in such a way that makes a strong argument for this not being a pre-existing condition. It's highly technical, and I don't want to recommend that you overthink this, because you can be too smart in trying to put in your application, but at least be aware of it if this timing applies to your application period.
So the next reason on our list is surveillance. So once you put in a claim for insurance, for disability benefits, the insurance company has a right to do surveillance. It doesn't have to be in a lawsuit. It could just be once you put in a claim. So surveillance essentially means, the traditional surveillance would be hiring a private investigator to follow you around for a few days, see what you're up to, take some video footage. These days, surveillance can also mean an intranet search of your social media presence, or, what are you posting on Facebook? But all of that is information about your day-to-day activities, and they will sort of use that as evidence to say, well, we saw you doing X, Y, Z, and so, if you are able to drive to Tim Hortons and go pick up your mother from the library and, drop off your kids at school, you must be able to work. Or they'll give you some sort of example to say, look, we saw you doing this, and that shows you're functional, so you must be able to work. I would say you can't really avoid them doing surveillance on you. And frankly, when I talk to clients about surveillance, I often say, I don't really care about the surveillance as long as you're being honest. Okay, because just because an insurance company sees you doing these things doesn't mean that you can work. Just because you're able to go to Tim Hortons and then turn around and go home doesn't mean you can go to work for 8 hours a day and do your job and satisfy your boss. So, how is that relevant in the application process? I'd say, be wary of it. Be careful what you're posting. Don't make an application one day and the next day show that you hosted a party for 100 people at your house. Anything crazy like that. But, so be wary of it. Be mindful that they are watching you. But, don't just say, oh, I'm going to stay inside my house and never do anything ever again, because that's not realistic either.
Next on our list, and it is a very common reason for claims being terminated for those that have been on claim for some period of time, is what we call the change of definition. And change of definition means that usually 2 years into an approved claim, the insurance company can cut you off if you're able to now work in any job as opposed to your own job. And that's the most typical situation in terms of a change of definition. In terms of making the application, it's again important just to keep in mind that initially the definition of disability under your policy that we talked about a little earlier may have some specific terms in terms of qualifying initially, and that may be focusing on, I can't do my job. But if you have the type of diagnosis that suggests that not only can't you do your own job, but you may not be able to do any job now or for the foreseeable future, you could get ahead of that. That might help the insurance company if they're inclined to approve you because you have a pretty solid diagnosis, that they should be setting up a reserve in their file. What a reserve is basically putting money aside because they think they may have to pay you for more than 2 years. And then it's not taking them completely by surprise that you've got a chronic illness and condition that makes it unlikely that you will ever be able to return to gainful employment. That may not apply to everybody that's making an application, but if you're into one of those categories, you can get ahead of that in terms of making them think right from the outset that you have a claim that could be going for an extended period of time.
And of course, if you go through your application with all of our suggestions about how to get approved and you still get denied, Share Lawyers is here for you to help support you and talk about next steps in terms of how to fight back against the insurance company so that we could get you the benefits that you deserve. You can call us at any time for a free consultation. There's no fees unless we win your case. So we're here and we're happy to talk to you and answer any questions that you have.
And now for something a little different on our show, we've invited our employment lawyer, Nick Goldhawk, to come and talk to you about employment law, and in particular how it relates to your disability claim and the interplay between disability claims and employment law and how to navigate that. We've found over the years there is a lot of overlap, and a lot of our clients have a lot of questions about the impact the disability claim has on their employment. So Nick is going to be able to hit some points that you will find helpful. And again, if there's a problem on the employment side, Nick will tell you how to get in touch with us and the type of cases that we can assist people with.
I'm Nick Goldhawk. I am the employment lawyer for Share Lawyers, so I deal with issues of all types relating to people's employment. Yeah, so there isn't necessarily a direct connection between disability disputes and employment disputes. It's almost like a coincidence that most people who have disability insurance have it through their employment, right? It's something that's provided by their employer. They get it in exchange for doing the work. And so when they're disabled, when they're unable to continue doing the job, then they can make a claim to the insurer. And, you know, in an ideal circumstance, when you've got a disability claim, your employer just kind of stands back, lets you handle things with the insurer, doesn't bother you too much. In reality, it doesn't always play out that way. Employers are often not very understanding of your situation at a very vulnerable time. So it's very common for people to have some kind of issue with their employer while they're dealing with a disability claim, whether it's your employer saying, you know, we don't believe you're actually disabled, whether it's them saying, we can't accommodate you, you're never going to be able to return to work. These are all types of issues that can come up with your employer while you're dealing with a disability claim. Lots of different problems come across my desk, but the most common legal issue is the termination of employment. So almost all employment related legal disputes have something to do with the termination of employment, even if the client doesn't know it at the time. So that's where most of the entitlements are, and that's where most of the legal issues arise. So in a lot of cases, it's the employer just making it clear, sending a letter saying, hey, you know, you've been terminated, and then we can determine what the entitlements are. Sometimes it's less clear, right? Sometimes, you know, the client isn't really sure what their status is. Maybe the employment situation has become intolerable. Maybe they've been put on a quote-unquote temporary layoff, and they don't know when it's going to end. Maybe they're dealing with harassment in the workplace and they don't know how to deal with it. These are all kinds of situations where an employer hasn't made it clear that the employee has been terminated, but a court can actually deem that you've been terminated if things get bad enough. You don't need to know whether your issue is an employment issue or a disability issue when you come to us. That's something we're going to figure out, and that's something we're going to advise you on. Our goal is to make sure that you're taken care of, that we provide you the best representation we can, that we come up with the best solution to your problem. And sometimes that might mean focusing on your insurer. Sometimes that might mean focusing on your employer. And sometimes it might mean both. But we're going to be here to help you determine that, and you know, we can help you no matter what that issue ends up being. As a disability law firm, we're very familiar with dealing with clients who don't necessarily have the financial means to pay upfront for legal services. So when we can, we try to offer contingency fee arrangements for employment cases as well, which means that we don't ask for our clients to pay anything upfront, and our fee is going to be based on the result that we can achieve for you.
You've been watching Your Disability Lawyers with David Share and Samantha Share. Contact Share Lawyers today for a free consultation and put our 35 years of experience to work for you. There are no fees unless you win your case.